Welcome everyone. My name is Jody King with the Alaska PTAC, the Procurement Technical Assistance Center, and I want to thank you all for joining us today. This is going to be a fabulous presentation by Mr. Howard Roth, who we'll bring on shortly. But before we do, what I'd like to do is go over a few housekeeping rules and explain the GoToWebinar panel. So just in case this is a familiar software for you, whether you've joined us on a mobile device or on your computer, in the GoToWebinar panel, there's a couple things I want to pull to your attention. First of all is on the handouts. So if you're on your computer, you can see a little caret. If you click on that to expand the handout menu, we do have copies of the slides. So if for any reason you are unable to download that, if you're on your mobile device, just email me. You can always reply to your webinar invitation and request that I send you the slides, and I'll be more than happy to. The next thing I'd like to do is talk to you about questions. There's a couple of different ways that we can do questions. First of all, there is a question and answer box, and you can enter your questions, and I'll be monitoring those. And Howard, if you want to queue questions during the presentation, feel free just to ask if there are any questions, and I will be monitoring the question box. If you're in a situation where it's too difficult to type in the question, you are more than welcome to click on the raise hand feature, and we can call your name. I can unmute you on this side, and we'll go ahead and have that conversation. We have a fabulous attorney with us today. I really want to encourage you all to get those questions entered, or at least be prepared. If not, at the end of the session, we will definitely have time for Q&A. So make sure that you ask those questions. Let's have that conversation. Please be brave. I know everyone is always hesitant in a virtual situation not to, but let's get those questions going. So feel free to enter them, or again, raise your hand and we'll go through that. So at this point in time, just a real quick reminder, Alaska PTAC, for those of you that are not familiar with the Alaska PTAC, is we are a not-for-profit organization. We're federally funded by the Department of Defense, the Office of Small Business, I just forgot what the P stands for, OSBP practices. We just moved out of the Defense Logistics Agency over under the Department of Defense OSBP office as of January, so new information for us as well. But what I'd like you to take away today is the Alaska PTAC provides free assistance with all aspects of government contracting. And the Alaska PTAC is one of 90 some nationwide. There's one in Guam and one in Puerto Rico. So if you are in an office that has multiple locations, feel free to check out your PTAC wherever state for that location, for that physical office. Each of us know our federal contracting, but each of us also have our expertise for that local state location. So enough about Alaska PTAC. If you don't know us, get to know us better. But really, we want to give our time to Mr. Howard Roth, who's a partner with Olds Morrison. Rinker and Briggs, I think, is the entire name.
Yes, Olds Morrison, Rinker and Baker.
Baker, there we go. I was thinking Briggs. I was cheating Mr. Baker. So Howard, at this point in time, you have the presentation. The screen is yours, and I'm going to mute my mic, and you are good to present. Thank you for joining us today. We really appreciate your time, especially addressing this subject.
Well, thank you very much. I'm very happy to be here. And what we're talking about today is getting paid on government contracts, which is, we all try to do the best that we can in our day-to-day jobs, and we expect to be paid. And a lot of times there are disagreements or disputes that arise on government contracts, and you want to try to resolve them as quickly as possible. And the two main ways to resolve a dispute are a request for equitable adjustment and a claim. And I'm going to go over both and try to give you some strategies so that you can get paid as quickly as possible when you run into a misunderstanding with the government. Just a little bit about me. I served as the commissioner of the Armed Services Board of Contract Appeals, which essentially decides most claims that are litigated with contracts with the Department of Defense. I'm also a retired colonel in the Army Judge Advocate General's Corps, and I, for over 20 years, advised contracting offices and major commands. And I've been in private practice now doing government contracts for over 15 years. So now I'm just going to go slide down, and it's not going slide down for me.
Go ahead and just click on your screen so that the software knows that this is what you're going to do. There you go. Now you can do your arrow key, or yes, use those.
Ah, yes. Okay. Sorry about that, folks. So a CDA claim, Contract Disputes Act claim, versus an equitable adjustment, a request for equitable adjustment. I give you just a little quick overview. A claim is clearly defined in the Federal Acquisition Regulation, what we call the FAR. If you look at FAR 2.101, and it comes from a law, from a statute called the Contract Disputes Act. Now, the irony is the Contract Disputes Act never defines it, but the FAR does. And what it is, and this is key, because you miss out on any of this, and years later the government will say you didn't submit a claim, and then you got to start over, and it's a horrible thing to have happen. And it happens a lot to contractors because it seems so basic. A claim is defined as a written demand or assertion by one of the contracting parties seeking, as a matter of right, the payment of money in a sum certain, that's really important, sum certain, the adjustment or interpretation of contract terms or other relief arising under or relating to the contract. So a claim can be raised by either side. The government raises claims, and we'll talk about that in a little bit. But what about requests for equitable adjustment? Well, a request for equitable adjustment is not defined in the FAR or really anywhere else. The term equitable adjustment appears expressly or implicitly in many places in the FAR and in contract clauses, like the changes clause. It will say you've got a duty to proceed with the work as changed, but you can submit an equitable adjustment. The suspension of work clause also talks about submitting an equitable adjustment. But the FAR and the contract clauses, they don't define what equitable is. So the courts and the boards, they basically look at concepts like fair and reasonable. Those sound like pretty easy terms to understand, but unfortunately, there are no hard and fast rules that will always assure agreement between you as a contractor and the government as to what is fair or reasonable. There are not even any rules from the various case law that will always assure success at the courts or the boards. Key differences: timing. Typically, with a request for equitable adjustment, the government doesn't have any timeline in which to get back to you. So it's generally where people start out. A claim, the government has to issue a decision on your claim within 60 days or tell you that they need more time. Certifications, both are going to require certifications. We'll talk again about the key. The key point is if you don't certify your REA or you don't certify your claim at all, then the government doesn't have to consider them an REA or a claim. Adversarial in nature, I think that's a key one. An REA, the government doesn't consider that to be you wanting to sue them. That it's a typical part of contract administration. Okay, there's been something that's arisen, and we're going to see what the cost impact is. Give us a change proposal. You can request an equitable adjustment, and you many times can work it out. A claim, on the other hand, is basically saying, I want a final decision and if you don't pay my claim, I'm going to go to court. And that leads to the other thing that's critical as far as the difference between a request for equitable adjustment and a claim if you're a contractor. The fees that you incur in talking to an attorney to put together a request for equitable adjustment, or a delay and disruption consultant, because you're trying to show what your critical path is and whether you head on delay, those fees for your consultant or your attorney, the government can pay those as a part of your request for equitable adjustment. When you draft a claim, the government cannot, they're prohibited from paying your attorney's fees for you drafting a claim or for your consultant. Now, there are certain limited situations where a small business in litigation may get their attorney's fees paid at a reduced rate, but that's going to be once the litigation begins, not for the claim. So most contractors, and generally my advice is most contractors start out with an equitable adjustment. Now, with a claim, you do get interest. So as soon as you submit your claim, interest starts to run on whatever that sum certain is that you've asked for. With an REA, there's no interest. So there is that trade-off. But generally what it means is that you're going to want to start out with an REA. So, Howard, you might ask, why are we even talking about a claim or an REA? What do you need this for if you're performing a contract? Well, you're going to need it for what we call monetary claims. That's damages that you've incurred, increased costs because the government has breached the contract, or costs associated with a change to the contract. There are also what are known as non-monetary claims, such as you've been delayed a certain number of days, and you need that additional time so that the government doesn't assert, say, liquidated damages. Sometimes also you need interpretation of the specifications or other non-monetary claims. One of the newest non-monetary claims that's been recognized by the boards of contract appeals and the Court of Federal Claims is when you get a CPARS evaluation that you disagree with, you can make that into a non-monetary claim, because you'd be saying, well, gee, my past performance was not marginal, like you said, it was excellent or outstanding. You can now make that a claim which the board can adjudicate. Reasons to file a claim or an REA are basically it's necessitated by some modification of the contract effort. It can be overt, it could be latent, it can be something that you might not have even realized at the time was a modification, what people call the death by 1,000 cuts type of issue. If it is something you realize up front, what can you do? Well, what I tell everybody is set up a job cost code. You want to track the costs. This makes your claim or REA much easier to put together. Also, you have to submit notice letters. As soon as you think there has been a constructive change or breach, you need to put the government on notice, because the clauses that you're required to comply with in your contract have deadlines, and they're 30 days, 60 days, and while courts and boards sometimes will waive the exact number of days, why play that game? I mean, as soon as you think that work has been added or deleted or changed or substituted, or you've been delayed or accelerated or disrupted, put the government on notice in writing that that's happened and that you intend to seek an equitable adjustment. Make sure your daily reports are specific to the issue that you've encountered and its impacts. Judge Clark at the Armed Services Board on any type of REA dealing with, for instance, construction, the first thing that he wants to do is to read the daily reports from the beginning to the end, because that should be the mechanism by which you're preserving the record as to what the government actually did to you. The other thing you're required to do is to mitigate to the extent that you can and track your costs and time associated with mitigating the impact of whatever change you've encountered that's leading to your additional costs. Very important. Don't sign the end of year mods that the government sends you asking you to deobligate and sign away all the remaining funds on the contract for that year. I know none of you would do that, but a lot of times these things get lost in translation, and the contractor is very shocked to learn that by signing that they've waived their right to submit an REA or a claim. Also at the end here, terminations for convenience. Of course, that can lead to what's known as a termination for convenience settlement proposal. A lot of people, when they get terminated for convenience and they put together their proposal, they think that that is an REA or a claim. It is not an REA and it is not a claim. It's exactly what it says it is, a termination for convenience settlement proposal. It's your proposal for what you think you should be paid. If the government doesn't pay you on that proposal, then you can convert that termination for convenience proposal into a claim. So what are your claim elements? And now we're talking about, claim, Contract Disputes Act claim, and not a request for equitable adjustment. So this is the more formal of the two. All claims must be presented to the contracting officer. You can't submit a claim to anybody else but the contracting officer. If you do submit it to someone else, then it is not a claim. And you don't want to find that out years later, because the court or the board will dismiss, as silly as it may sound, they'll dismiss it because it wasn't submitted to the contracting officer in the first place. If a claim is for more than $100,000, then it's subject to the certification requirements in the Contract Disputes Act and in the FAR. And for those of you that want to take some notes, the FAR provision is 33.207, and the Contract Disputes Act citation is 41 United States Code section 7103. We always got to throw some numbers and code provisions in there to make it legal, but if you don't have that certification, you're in deep trouble. Now, is there a particular format for a claim? The answer is no, but it has to satisfy the elements above and contain sufficient information to show your, as a contractor, your basis for entitlement and the relief, the amount of money that you would like. Again, this all sounds sort of straightforward, but the definition of a claim does not include that you must request a final decision. That's been added to the definition by the courts. If you don't request a final decision, again, years later, the courts can dismiss your claim after you spent thousands and thousands, if not even more than that, litigating. Well, you didn't request a final decision, so it wasn't a claim. So it's very important to request that final decision, to make sure that that you have a certification, and to make sure that it's a sum certain. Very, very, very important. Now, I'm sure a lot of you have heard of the construction company Kiewit. Well, they had a case that was decided by the Federal Circuit, which is sort of the Supreme Court of government contract law. And the Federal Circuit, that court, they held that a certified claim for constructive change was valid where the claim referenced back to a prior REA. The court found that the claim does not need to be issued in any particular form or wording as long as the CO clearly had adequate notice of the basis and amount of the claim and issued a final decision as it did there. So, you know, the government is always, the first thing they're going to do, a lot of contractors think, well, you know, the government, now that I've filed my claim and I've appealed to the Court of Federal Claims or to the Board of Contract Appeals, we're going to get to discuss the merits of whether or not I should be paid. And the answer to that is no. The first thing the government is going to do is fly-spec your claim and file a motion to dismiss saying that it's really not a claim. And time again, this happens. And, you know, that's why you always want to have an attorney look and assist you with your claim. It is not self-evident.
Howard?
Yes.
This is Jody. I apologize. I forgot to ask before we started. Do you want questions as they come in, or do you want to hold them to the end?
I can answer questions as they come in if there's a question.
We do. We actually have a couple over the last couple of slides. So the first,
then let me answer them.
Sounds fabulous. Thank you. So the first question is, how long do they have to respond to a settlement proposal?
They have no timeline. There's nothing written. If you actually get into a case where you're going to litigate how long they took, you know, you're going to argue that they didn't respond in a reasonable manner. But what's your remedy if they don't respond is to submit a claim. So if you don't get a response, you've got to convert that request for equitable adjustment or that settlement proposal into a claim. There's nothing that you can point to in the FAR that says an REA must be answered within X number of days. However, a claim must be responded to within 60 days, or the government has to ask for more time to prepare their response, which is the final decision.
All right, so in the case of a termination for convenience and you submit a proposal, is there a time limit for that as well?
Again, when you submit a termination for convenience settlement proposal, the contractor has to submit it within a year. If you don't submit it within a year, then you're done, okay? Unless you got an approved extension in writing from the termination contracting officer, the TCO. But if they don't respond to your proposal, or you just aren't able to work it out with them, what you've got to do as a contractor is convert that termination for convenience settlement proposal into a Contract Disputes Act claim, just like you would convert an REA into a Contract Disputes Act claim. Now, I'm jumping ahead of myself a little bit, but I'll be talking about in the slides later on. What the government does that confuses contractors is a lot of times they'll issue a determination on your termination for convenience settlement proposal, and it won't tell you that it's a final decision, and it won't tell you that you've got 90 days to appeal. But the courts and boards have ruled that determination by the government is a final decision, even though it doesn't say that it is. So you've got to be careful about anything you get in response to your termination for convenience that says it's a determination. But there's no set amount of time for the government to, you know, there's nothing that you can point to that says, oh, you've taken, you know, 10 years. It's too long. If they're taking too long, then your remedy is to convert it into a claim.
So the rest of the questions are regarding the termination for convenience. So let's hold the rest of the conversation for the end of this, just to make sure that we don't run out of time. And then time permitting, we can talk more on that T4C proposal process.
Sure.
So Heather, I'm going to hang on to your questions and then we'll come back to the rest of the questions regarding that. Thank you, Howard.
All right, I think, yeah, can the government assert a claim? Yes, it can. In fact, you know, a termination for default is a government claim, because unless you appeal that termination for default, that final decision, then it can become it becomes a claim against you for the government to have you pay the cost to complete the contract. Also, liquidated damages is a government claim. A DCAA audit that finds unallowable costs can be a government claim. So the government can and does submit claims against contractors. What cannot be a claim? Well, that it's nothing pre-award. The Contract Disputes Act only governs post-award claims. If you have issues pre-award, if you will, I mean, there are certain issues that you can file protests on, but not claims. Tort claims are not relating to the contract because torts are not contracts, they're torts. It's a whole separate area of the law. Prevailing wage disputes under the Davis-Bacon Act, that is not a Contract Disputes Act claim, that's the Department of Labor. Now, everyone says, Howard, why are you talking about some certain? Because people mess it up all the time. And I guess I got to make clear what happens, the horror of it, okay? You're a contractor. You submitted a $2 million REA. The government wouldn't get back to you. You converted it to a claim, all right? And in your 50-page claim that has 100 exhibits, you said that you were claiming not more than $2 million or approximately $2 million. And you go and you appeal it and you pay your attorney a couple $100,000 to litigate it. And the day before trial, the government attorney will show up smiling, ear to ear, and this is perfectly legal, and throw down a motion to the board that will say, Your Honor, I'm sorry, but we got to ask this to be dismissed because there's no jurisdiction, because no claim was submitted, because there was no some certain. And if you use the word approximately, you will be dismissed. And if it's more than 6 years from when you knew or should have known for the claim, then you're going to be barred. And the government does this all the time. It is critical that you assert a some certain. Ceiling amounts for claims are not some certain. A some certain has to be a definite number. And some certains are required also for claims litigating, liquidated damages. In this appeal that I have right here of High Tech Laundrette, they did a qualified request of approximately $150,000, and the board said that failed to state a some certain, and thus could not be a claim, and therefore the board had no jurisdiction. In the appeal, the quote that the court used was that this company said approximately $150,000. The claim to the contracting officer requested a monetary amount estimated to be in excess of $150,000. Again, not a some certain. It also said it was requesting breach damages consisting of a minimum of $150,000 in lost revenue. Again, not a some certain. If you want $150,000, then you should just say, as a matter of right, my claim is for $150,000. No ifs, ands, buts, or qualifications. You qualify things at your own, I guess, peril. And another reason to get an attorney involved at the REAs, or just a consultant, or just even to think about this is, if you left something out of your claim, it's too late. You can't say, oh, but there's this other $200,000 for this or that. So when you're putting together your some certain for your claim, remember your delay costs, your home office overhead, your field office overhead, your disruption and inefficiency. If it's not in that some certain, then the court or the board has no jurisdiction to decide it. So what are allowable costs? Rain, let it rain money for us. Reasonable, nature, amount, mitigation. Mitigation is important. If you've got, like I said, mitigate the damages that you're incurring, you can get paid for the mitigation. You got to keep track, open up that cost code. Allocable, direct costs, we know what direct costs are. Overhead, we know what overhead is. General and administrative, don't forget any of this. and it's got to be in accordance with the cost accounting standards or generally accepted accounting principles. Now, we all know that for small businesses, the CAS doesn't apply, but the government is king, and that's what you got to remember. I, have been in negotiations on a termination for convenience. I was in a negotiation yesterday without talking about client or anything, who it was. And if it was a small business and the termination contracting officer is saying, well, you didn't comply with CAS, so we're not going to pay this. And I pointed out that CAS doesn't apply to them. And what the TCO said was, that doesn't matter. I know it doesn't apply, but I can still look to anything, and I'm looking to CAS. So even when it doesn't apply, you got to know when to beat a hasty retreat. What do you do then? Well, then what you do is you say, well, on these other issues, remember that it's supposed to be a fair and reasonable settlement of my T4C proposal, and therefore it wouldn't be fair or reasonable to expect me as a small business to be able to comply with CAS, and that may win the day. It can't be in conflict with the contract. I mean, you can't ask for costs that the contract doesn't allow, and it can't also, there's something that's known as the cost principles. It can't violate that either. So, reasonableness of cost. The FAR has a definition. If it's reasonable, if in its nature and amount, it does not exceed that which would be incurred by a prudent person in the conduct of competitive business. Well, clearly that statement is subject to interpretation, but the burden is on you as the contractor to show that it's reasonable. To give you an example, in an REA, you as a contractor have to show that your attorney's fees that you've paid on an hourly basis to get your REA done are fair and reasonable. And what I always put in there is that the Department of Justice for 2020-21 has said that for an attorney like myself with over 30 years, that a fair and reasonable hourly rate is $670 an hour. Now, I'm less than that rate. So what I always say is, well, the government has published, here it is in black and white, that 670 is what they'll pay as fair and reasonable for an attorney with government contracts experience over 30 years. I'm less than that. So that, I have my contractor say, this is clearly Howard's a reasonable cost. He's below what the government considers to be a fair hourly rate. Again, it's your burden. So, pointing to things like a published rate that the government has published is certainly going to help. Profit and interest. Again, profit is it's just an interesting area, because especially in terminations, because if you were really making a great profit on your contract, it might be well above the weighted guidelines that the government typically considers to be reasonable and customary. And for terminations, there's a whole definition of what you can do with profit, and that means that you generally have the door open to get more. But just for a normal change, the government, they do try to use their weighted guidelines, but a court or the board is not going to be bound by that. Don't forget, G&A should not be excluded from the profit calculation on your REA. And you can get interest, like I told you, on a claim, but you cannot claim any interest you paid as a result of, for instance, financing costs. Certifications, again, this shouldn't be an issue, but it still is. If you don't include a certification, then it's not a claim, okay? You are allowed to cure a certification that's not written correctly, but the certification has to be signed by an identifiable mark. Luckily, recently, the board has overruled its prior precedent, which essentially was that you had to sign it in pen and ink. And now, so long as it's a mark that can be traced back to the individual. It can count as a signature for the purposes of the CDA through a digital signature, of course, signed in ink, or if it's a typed name, but it can be traced back to the person who, for instance, sent the email. But up until 2020, people were getting their appeals dismissed because they signed it, with a digital signature on an email block. And again, 3 years into the litigation, the board said, well, it's not signed. Because it's not signed, it's not a certification. But it came from my email address, But that's how the government fights these things, ladies and gentlemen. They're going to try to find that you didn't submit a claim. Timeliness, you've got 6 years from when you knew or should have known about the circumstances of your claim arising. You want to submit your claim as soon as possible. You want to try to submit an REA and settle it and get your attorney's fees and consultant, but you don't want to dicker around too long in negotiating, because it's not from when you basically, the negotiations break down. It's from when you knew or should have known that you had a claim. And it doesn't even go back to when you started to incur damages. The case law talks about when you essentially had a harm. So that's pretty nebulous. Someone had asked earlier about, is there a timeline on the REAs for a decision from the contracting officer? And the answer is no. However, on a claim, if it's under 100,000, then they have to do it within 60 days. Or if it's above 100,000, then within 60 days, they've got to tell you a reasonable amount of time that they're going to get back to you in. It's important, though, that if the claim is over 100,000, that you actually demand the CO's decision within 60 days. If you don't do that, then the 60-day deadline doesn't really kick in. So that's another thing, to be aware of. Just so you know, if you really want a contracting officer's decision, if you think that it will get you money or time, and the contracting officer is dragging their feet on the decision, you can go to the Board of Contract Appeals and file what's known as a petition to force the contracting officer to issue a final decision. And I've done that for people, again, in situations where we thought it would have a positive impact. Now, if you don't get your decision within 60 days, then you can do what's known as a deemed decision. If you see, because to appeal, you either need a final decision or you need a deemed decision. But the thing that really, really upsets clients and contractors is you got a final decision. It's 100 pages long. In detail, it states why the claim shouldn't be paid. Then 2 years later, that government attorney, with a grin ear to ear, throws down his motion to dismiss, saying, well, Your Honor, it wasn't a sum certain. And you as a contractor and me as your, what do you mean it wasn't a sum certain? They issued a 100-page final decision. It doesn't matter. The fact that a final decision was issued doesn't cure any defect in your claim. Always remember that. Now, what happens if you get a response from the CO, but it doesn't contain all the elements of an official rejection? This is another sneaky thing that the government has. And I mentioned this with terminations for convenient settlement proposals, where you'll submit your proposal and they'll come back with a one-sentence thing that says, we've made a determination on your proposal that, you don't get anything. See you later, have a nice day. Well, what the courts have said is that's an appealable final decision. So you've only got 90 days to go to the board or a year to go to the court. So in Hoff construction, the agency stated the courts and the board said that it doesn't have to be perfect, and it doesn't have to include the exact language of FAR 33.2111. You know, really, if you're a contractor, that's manifestly unfair, because if you read FAR 33.211, that's the language where it tells you that you've got 90 days to go to the board or a year to go to the Court of Federal Claims. But what the courts and boards are saying now is, even if it doesn't have that language, you're supposed to know. Very unfair, but that's the state of the law. Appeals. You've got to file your appeal. If it's either denied, you get something in writing. You can also, if you want to, appeal on a deemed denial basis. In other words, you don't get a response within 60 days. You then have 90 days to go to the boards of contract appeals. The Armed Services Board of Contract Appeals is responsible for decisions from the DoD, Army, Navy, NASA, and when specified, CIA. The Civilian Board takes care of all the civilian executive agencies, except the Postal Service and the Tennessee Valley Authority and the Federal Aviation Administration. As far as going to the court or the board, we could talk for a day on that. I mean, in general, it's just less expensive to go to the boards, and most people go to the boards. If it's a maritime contract, though, and you want to go to a court, you can't go to the Court of Federal Claims. You've got to go to district court. And that tricks people up a lot. What's a maritime contract? Well, it's anything having to do with navigable waters other than construction of a ship. Construction of a ship is not a maritime contract. So now let's talk, a little bit about REAs. We've talked a lot about claims. The request for equitable adjustment is what I'm typically helping people with. It's a less formal request. It's a negotiation in furtherance of contract administration. So that's why you get your costs, pricing and scoping, from your consultant for delay and disruption, or from your attorney. You've got two things that you've got to prove. Entitlement. Entitlement means that there's a legal reason for you to get paid. And then if there's a legal reason for you to get paid, you've got to show the quantum, the amount of money or the time. A lot of people get confused on that. They do a great job on entitlement, but not on quantum, and so they get nothing. Even in board decisions, they'll get nothing. And it's extremely frustrating for them. And remember, just like with the Contract Disputes Act, the REA has to be certified. In REA certification, I certify that the request is made in good faith and that the supporting data are accurate and complete to the best of my knowledge and belief. Got to have that on there, and what that means is you're opening yourself up to, a false claims prosecution. So you really want to make sure that what you put in there is supportable with actual cost or pricing data. You want to, what is a good REA? People ask me that. A successful REA should have a clear factual narrative, 100 numbered facts with a piece of paper or an email to back up every fact. Then the legal cases that show that you've got a legal reason under the changes clause or suspension or whatever, and then something that supports what your actual costs are. You've got to have the invoices. You've got to have the backup information all in there. That's what you need to have. And it can be a lot of work. Attorney and consultant fees for requests for equitable adjustment, but not for claims, all right? The monies that you pay to your attorney or consultant, and this applies to termination for convenience settlement proposals, they're allowable. For REAs, what the boards have said is they look at the reason that you incurred the cost, and if it's for the genuine purpose of materially furthering the negotiations process, then the costs are allowable, even if the negotiations fail and a claim is later later submitted. What that means is if you have a claim for $2 million, an REA for $2 million, if you have a request for equitable adjustment for $2 million, you pay an attorney $50,000 to put it together, and the government doesn't pay you, then your claim is not 2 million, it's 2,050,000. You get to add the cost of your attorney to your claim as a reasonable claim amount. Which one do you want to choose? Well, it comes down to almost always, in my experience, it's the REA, but it comes down to the relationship between the contracting team and the contractor, and the government agency. Are you negotiating other contracts or an option, or do you have outstanding bids? How confident are you on your entitlement? What's the history? People go directly to a claim when they know that the government isn't even going to read their REA. Why waste the time? Let's just go and fight it out in court. Very important, conversion of your REA to a claim. If you do things right, it should be very easy to convert your REA, which the government has to pay for because it was an REA, your consultant fees and your attorney's fees. Again, if you prevail on entitlement, and you just would have to put on a cover letter that says, I convert my REA into a Contract Disputes Act claim. I am requesting $150,000, sum certain as a matter of right, and I hereby request a contracting officer's decision. Thank you very much. Then you've converted it to a claim. Sometimes people, though, don't put as much effort into their REA, and so you want to look, are there any additional legal theories that you want to add? To include amounts that you want to ask for. This is the time to figure that out. Also, to add more details, make sure that you have a proper certification and that you request a contracting officer's decision. As far as maximizing recovery during the COVID shutdown periods that everyone is, or that some people have experienced, one thing that you can do, and this applies to, if the government indicates that it agrees to a portion of your REA, but claims that there aren't any available funds, and this doesn't just apply to COVID, but any situation where the government says, we want to pay you, but we don't have any funds on the contract. Then what you need to do is convert your REA into a claim, do an appeal to the board, which only is like a one-page letter, appeal on a deemed decision. That way the government doesn't have to do anything. And then the government can sign a settlement agreement with you, and then you're paid not by funds from the agency, but from what's known as the judgment fund. And the judgment fund, think of it, the judgment is a fund that it's like a stream of money. Think of like a spring where $100 bills are perpetually flowing out, okay? Just think about it. And it flows out into a big sea. And whenever the government needs any money, they just go in there with a big scoop and they scoop out millions or billions or whatever it is they need. It's what's known as the permanent indefinite judgment fund. The theory is that later on, the judgment fund will go back to the agency and get reimbursed. I will tell you, the Pentagon, if anyone, you can Google this if you don't believe me, cannot be audited. They've been trying for years. So whether or not that actually happens, who knows? But that's a way around if they say, oh, we don't have any money on the contract. Well, then let's just go and file a deemed denial appeal and get paid from the judgment fund. Now, you don't want to be in litigation with the government. I just went over just a few of the tricks they'll pull, with, 6 years later saying that you didn't submit a claim. They also have unlimited resources. I mean, they have people on salary to litigate these things, and they take a long time, okay? So I really try to use alternate dispute resolution. And and a lot of people don't know this, but the boards of contract appeals will provide a free mediator at no cost to you, paying all of the travel and per diem costs for claims and REAs even before a CO's decision is received and before there's an appeal. This is known as off the docket ADR mediation services. And they'll do the same thing to mediate an REA before it's converted into a CDA claim. The key is the government has to agree to do the ADR. I mean, if they don't agree, again, they're the king, they're in the driver's seat. They should, you know, the statute, again, what you do, the statute says is that if they don't want to do ADR, they have to give you a reason. So you have to ask them in writing, we want to do ADR. The Contract Disputes Act says that you have to give me a reason for not doing it. What's your reason? The success rate for disputes that go to ADR at the board is staggeringly high. I mean, you can go on their website and they have the statistics. It's, you know, it's 100% some years. It's well over 90% most. In the last, since 1978, it's like 93%. You know, outside of this COVID period, the judge normally travels to the contractor's location for these mediations. You know, key things to consider. You've got to submit a claim to the contracting officer for final decision. And you may think it's a claim, but does it assert a sum certain as a matter of right? Does it ask for a contracting officer's decision? You got to make sure you hit all those. And you got to make sure that you've asked for all the money that you're entitled to, because it's too late once you've submitted your claim to make it bigger. There is something that's known as natural growth, you know, numbers that like with let's say a lumber contract where, you know, you can show that there's an impact that's continuing, and so the number will go up. But you want to always assert, right now, our sum certain is 500,000, but it continues to grow with natural growth. But you really want to be careful the words that you use, again, because of those decisions that say anything that says approximately or up to or whatever is not sum certain. Got to be available. Understand that bad faith is going to go nowhere with the government. Allegations against the government clients for contract termination just don't hold up, because government clients, the government is always presumed to act in good faith in the execution of their duties. So you can never, it's extremely difficult. There's a couple cases out there on bad faith. There is something what's known as the breach of the duty of good faith and fair dealing. That's something entirely different than bad faith. And that, you know, if the government hasn't cooperated with you, they haven't acted in good faith. That is something that's proven quite a lot against the government, but that's different than bad faith. You know, neglecting to conduct due diligence needed to track and record work to quantify damages. No proof of damages was shown, so no causation was established. I mean, you know, typical of a case that came out where after years of litigation, the board said, you know, on this commercial item contract for tents for the Army, you're right, you're entitled to money, but you did not put in your contemporaneous cost data, and the testimony of your president as to what the costs were wasn't enough, therefore you get zero money. So you've really got to make sure you've got, you know, documentation to prove your quantum, how much you got injured. Real, not some spreadsheet or after the fact Excel thing that you put together, but actual documents from the time. And also allegations that third-party actions have interfered with the delivery of the contract terms for which the government client cannot be held responsible in the absence of specific contract terms. In other words, if, you know, if the another part of the government does something that impacts the contract, but it's not the part of the government that you have contracted with, then that's not going to work for you, unfortunately. Well, I'm here at the end. I know there were some questions on terminations. I'm willing to take any questions that you have.
All right, thank you, Howard. So everyone, if you have any questions, this was a lot of great information. Let's go ahead and get those in now. We've got about 5 minutes left, so let's take advantage of the time. So one of the questions I want to ask Howard on the REA process. So we have a contract in place, change is triggered. Do we need to have an REA submitted before we can go to a claim process? Or can you jump the REA process and go directly to a claim?
You could, if you wanted to, submit a claim right away, but I mean, I wouldn't, generally that's not going to be advisable, because what you would do is you would, let's say that you're building a building at Fort Wainwright, and you have a problem with the plans and specs as far as on the thickness of the wall, and you go and say, we're going to have to do X, Y, and Z, contracting officer, and it's going to cost us more money. And the contracting officer comes back and says, no, do it as the plans and specs call for, you get no money. What you've got to do then is say, here's my notice of a constructive change. That's the first thing you've always got to do. And I intend to submit a request for equitable adjustment. After you submit that notice, I would recommend you submit an equitable adjustment. But if you don't want to, if you want to make a claim right away, then you could do that. You wouldn't get your attorney's fees paid for. You'd be in litigation with them. A lot of the negatives. But I have helped people go straight to the claim situation. But even if you go straight to a Contract Disputes Act claim, you still got to give the notice that there was a constructive change, that there was a differing site condition, that there was a suspension of work. You can't just, you got to, because otherwise you won't have complied with your own contract.
Okay, so Robert has a follow-up question to mine. He's asking if the government is not responding or rejecting an REA, should you request a response before submitting a claim?
Well, I think it's, I mean, if you submit an REA, at the end of the REA, I would typically, say, we would request your response within, the next 45 days, and we stand by to meet with you to negotiate. And at the end of that 45 days, you tend to follow up that would say, we haven't heard back from you. Are you going to give us a response to this REA or not? And if not, when? And if you still don't hear, that's enough. I mean, I wouldn't just submit the REA without following up to try to push for a response. But since they don't have to respond to you, at a certain point, you just want the court or board to see that you, in good faith, did try to resolve it. It helps you in the eyes, especially of the board.
Good answer. That makes a lot of sense. If you have one of those very special contracts and you have, and this is again me asking, not from one of the attendees, and you have multiple, or I always think of that domino effect of all of these multiple REA, multiple adjustments, multiple scenarios, is it best to submit at each point? Do you try to roll up just for the paperwork cause? If you really have a contract that is not going smoothly and there is a lot of changes and impacts, do you have a recommendation on effectively submitting all of those changes? Should they be individual? Should we try to encapsulate?
Well, what generally happens is that you don't, once you have one or two constructive changes, and if the government's telling you they're not going to pay you, well, then you realize that there's an issue, and you're going to have to put together an overarching REA, and it's generally a good idea to all REAs about at that time, within like if it's been 2 months and you've got 5 outstanding, to put them together as one. It tends to make more sense to put one big REA together. Again, without delaying the process so much that it's no longer timely.
Correct. That's a good response. And my add-on to that for the audience is, if you have that kind of circumstance, reaching out for assistance, finding whether you speak with an attorney or a consultant, definitely seek help, seek the assistance you need to resolve that before you lose that time and before it becomes just consecutively worse.
Right, because under the changes clause and under government contracts, the thing that makes it, you've got this duty to proceed. So, you know, whether they're paying you or not, if they've told you proceed, you've got to, and so you're incurring these additional costs, and the only way you're going to be made whole is to get paid your REA, and if that doesn't work, then to get paid on a claim.
Thank you. Heather, I apologize. I did kind of run you out of time. I know you have quite a bit of a conversation regarding your T for C, and that might be something, just based on your questions. We did talk about how long you should wait to transition a settlement proposal to a claim. I think that's really about the only thing that you didn't mention. But if you want to take that conversation offline, you might have more success than just the few questions and comments that you've added. And
yeah, Heather, I'd be glad to talk to you. You've got my email and my cell phone here. At the end, just let me know when you would want to chat.
And the last question that we have, and we're kind of running over time, so this definitely will be the last. Robert is asking, for COVID shutdown cost claims, have you seen precedents for reimbursements for costs related to remaining ready to return to work?
Well, you know, there's no really reported decisions is the thing. So it's all sort of word of mouth. You know, it all depends on your relationship with the contracting officer. If you are suspended and you're on standby, then you need to invoke a constructive suspension, and you know, you can be paid for your costs under the suspension of work clause. The problem with the suspension of work clause is you don't get profit. So what most contractors try to do is they're suspended to try to look at the authority that looks at it as a constructive change to the contract, because for a change you can get profit. But the key thing is you got to write your notice letter. But because if you actually go and you try to litigate these things, it takes, you know, 2-3 years. There hasn't been enough time to have any reported decisions.
Thank you, Howard. Well, everyone, I want to, and Robert says thank you as well, Howard. So
Robert,
I want to
thanks for your questions.
Good questions. So
Yes.
I want to thank everyone for attending today. Howard, especially, thank you so much. I realize you're an incredibly busy man, so we truly appreciate you taking the time to present on this topic for us today. Everyone, you have his contact information on the screen. And of course, if you have any questions after the fact, you're always welcome to reply to your webinar invitation email to me, and I'll be glad to forward those questions on to Howard or work with you on getting response. ETAC here is here to assist you, of course. And so at this point in time, a final thank you everyone for joining us. And I am going to officially close this webinar.